Mr. Fuller, you want to call the roll?
Right.
Emily?
Good morning, Mr. Chairman. This is an attendance roll call for April 25th, 2023. Senator Case,
Present.
Senator Cooper,
Here.
Senator Murphy,
Here.
Senator Schuler,
Here.
Representative Chestick,
Excuse.
Representative Crago,
Excuse.
Representative Haroldson,
Here.
Representative Jennings,
Here.
Representative Nemec,
Excuse.
Representative Oakley,
Here.
Representative Provenza, Representative Rodriguez Williams,
Here.
Co-Chairman Washut,
Here.
Co-Chairman Landon.
Here.
Mr. Chairman, you have a quorum.
Thank you. All right, welcome to second day of joint judiciary here in the beautiful city of Sheridan. We're glad to be here. Today we have a couple of different topics. We're going to have judiciary topics this morning and corrections topics this afternoon. So let's get going. Have a great day. Good to the order. These were found in the, anybody lose these? Anybody? Okay, well.
Those are mine. Were those right here?
No, they were, I don't know, someplace. Lost and found. All right. Mr. Chairman, Co-Chairman, you have any comments this morning?
Thank you, Mr. Chairman. I just wanted to take a moment, committee, thanks for all the efforts yesterday. We ran a little bit late last night, but I felt like we got through some important topics. Wanted to thank you for that. You know, we kind of become a family doing this kind of work. All of those in the audience today, and even those streaming in, and our professional staff, the committee. And so last night when I heard this, I just wanted to share it this morning. We had brought up the notion of working closely with the Wyoming County Commissioners Association on a couple of issues yesterday. And I learned that Jeremiah Freeman is going through some difficult times. The health of his wife. And so I wanted to share that so that everyone could keep him in their prayers, and of course his wife too. But Mr. Chairman, that's it for this morning. Take it away.
All right, first topic today is Judicial Branch Administrative Office of Court Staffing, Wyoming Supreme Court. Who's going to present this morning?
Good morning, Mr. Chairman.
Good morning,
members
Madam
of the
Chief
committee.
Justice. Elisa, thank you for coming today. I hope you had comfortable accommodations and that you didn't drive up this morning, did you?
I did not.
Good,
Thank
good.
you. And
Very
there was
good.
no baseball team in my motel, so it was good. I am Kate Fox, Chief Justice of the Wyoming Supreme Court. You probably all know Elisa Butler, our state court administrator. I'd like to introduce a few others from the judicial branch who are here today. Justice John Fenn is sitting behind me. And Judge Snyder is hiding back there. Judge Snyder is the district court judge in Rawlins, and I think also Judge Cundiff, who is the circuit court judge here in Sheridan. So thank you all for your time and attention. I actually wasn't going to come to this meeting, but then in a conversation with the co-chairs, they suggested that I might just give you an update on things that are happening in the judicial branch. So I don't want to take too much of your time. I know you've got a lot of business, and I won't repeat the kind of civics lesson that Justice Couts and I gave at the beginning of the session. Instead, I'd like to talk about some of the innovations in the judicial branch that we've been working on. We started throughout 2022, we had a task force called Judicial Branch Innovation that was made up of 2 Supreme Court justices, 2 district court judges, 2 circuit court judges. Elisa Butler took part, and it was facilitated by the staff of the National Center for State Courts. And the purpose of that was to look at our branch and think about the way that we've done things for 100 years and see if it really still works, especially in light of many of the changing demands in our society and on the judicial branch. So as a result, we came up with a strategic plan for one thing. And I just thought I'd talk to you about that a little bit. So the strategic plan, first, we did the usual thing, which is a mission statement and vision statement. I'm not going to read all this to you. You have it in front of you. But the basic idea was to recognize we have 24 circuit court judges throughout the state, 26 district court judges, and 5 Supreme Court justices. And each one of the judges and justices is independent in the sense of making their legal decisions. However, it's important for us to act as a branch and to be cohesive in our message and in our planning and in our resource development. And so the mission and vision statement cover a lot of things, but the main idea is that while preserving judicial independence, we do act as a cohesive branch. And then we broke it down into 5 priorities. And I've just highlighted a couple of the things that we are already working on. So number 1 is access to justice. And that's because the first job of the judiciary is to provide people with an opportunity for accessible resolution of their legal disputes. So one of the things that we realized, I've highlighted some of the things that we're working on right now, and not to say that the unhighlighted items are not also important, but these are front and center for the moment. We're working on getting a court navigator program, because one of the things that we've realized is that there are more and more self-represented litigants or pro se litigants. And that makes it hard for them to get their disputes resolved, because it's pretty difficult to navigate the court system if you're not trained as a lawyer. But it also makes it really hard for the judges, because when they have self-represented litigants trying to get a divorce in front of them, they don't know really how to fill out the forms or how to question a witness. It puts the judge in an awkward position because they're not supposed to help one side or another. And it just bogs down the process because it's much less efficient. So this program, a court navigator program, which we're working on establishing a pilot in Natrona County, would put somebody in the court who would help self-represented litigants to fill out their forms, not provide legal advice. It wouldn't be a lawyer, but somebody who can say, here's how you do this. Here's the form that you use. When you go to court, this is what you need to be able to do. So I think this will be of great assistance to both the litigants and the judges. The other thing that I have highlighted, and you'll hear more about today from the bar, because the bar and the law school have taken the lead on trying to promote more attorneys in rural areas. There are places in Wyoming where you can't find an attorney, and that's even if you can afford one. And for example, if you're in the basin and the judge needs to appoint a parent counsel for a parent in a juvenile case, there may not be anybody available in that community. So I won't talk a whole lot about this rural practice issue, because I think that's on your agenda for later, but I think it is an important program, especially not in Cheyenne, Casper, and Jackson. They have plenty of attorneys, but in almost every other community, there are fewer and fewer, and they're all getting older. So number 2 is effective operation of the judicial branch. So we want to continue to do good work as judges and court employees. And there are some ways that we've identified to do that better. And again, I've highlighted the ones that are priorities right now. So to formalize and fund the use of retired judges. We've been using retired judges in some courts where they're needed or where there's been a vacancy, and it's been really effective. And one of the things our judges told us, we took a poll at the beginning of this JBI project, and they said, we can't take a vacation because it's too hard to leave and have someone, there's no one to cover their cases. So that's something that we're also working on. And then we are continuing to develop judicial education so that we have a lot of new judges, and old judges need refreshers as well, just to provide information on how, for example, to decide on evidentiary rulings or how to deal with self-represented litigants, some of the newer things that we're having to face. And then at the bottom, I have highlighted to enhance the use of problem-solving courts. So by that, I'm talking about treatment courts, diversion courts, because one of the things that is a true dilemma for the judicial branches really all around the country is the real epidemic of people with mental health and substance abuse issues. And we recognize that the way we're managing that now by charging them with a crime, incarcerating them, waiting for a competency evaluation, and then releasing them without any treatment is the most expensive and least effective approach for many people, or not all of them. And what we're focused on in the diversion plan that I think Elisa will talk to you about a little bit later is misdemeanors, so low-level nonviolent crimes, to see if we can divert them in a more constructive and cost-effective way. So public trust and accountability is an issue that we've identified as really important, because I think historically judges have thought we just do our job, we mind our own business, we don't need to sell ourselves. And I wish that were true, but I don't think it is anymore. And I think people need to have a better understanding of what judges do, especially state judges, because we are not the United States Supreme Court, which has given us all a bad name these days. And I don't mean that as a reflection on the United States Supreme Court justices. I think that their selection system is what's given us a bad name, but we're not them. We have 55 judges who work so hard to apply the rule of law and take care of people, and who are not political. And I think we need to do more to send that message. So one of the things you will also hear about when we talk about administrative office of the court staffing is the need for a public information officer. And that's not just to help us tell the story of the judiciary. We have found that we spend a lot of time, our staff does, providing information and data to people, to the legislature, to other agencies, to newspapers. Everybody wants data, and they should. And we should be transparent. So we really need some help in managing that information. And then also I've highlighted the training judicial officers and court staff in the procedures for entering data. The legislature did give us a position for that this last session, which we will try to fill in July. To help train people. So we have these pretty wonderful case management systems. Everybody enters data. Don't forget, our district court clerks are elected and therefore somewhat independent. And our circuit court clerks are actually employees of the branch, but they can be very independent too. So it takes a lot of training just to get everyone to enter the data the same way so that what we produce is reliable. And then finally, to get all this done, we need adequate, stable, and predictable funding for the branch. And we'll probably be talking to the legislature about that for at least as long as I'm still on the court and into the foreseeable future. So I just wanted to give you that overview. I also wanted, I offered the co-chairs when we met a couple of weeks ago that they should go to their courts and meet with their local district court and circuit court judges to see what it is that they do. And I would invite all of you to do the same thing. Representative Oakley, you probably don't need to do that, but yeah, right. But if any of you don't know who your judges are, Representative Nemec, you're probably okay too. But I really do urge you to just call up your judges and say, when can I come and get a tour and see what you're doing and sit in on a case? Because what they do is really very impressive. If you don't know who your judges are, let us know and we'll send you an email introduction and set that up. So that's all I have. But I would be happy to take any questions, Mr. Chairman.
Madam Chief, I appreciate the comments and congratulate you on development of the strategic plan. Look forward to working with the judicial branch, try and do our part in helping move that forward. I do have one question. I like the idea of judges getting a vacation now and then, you know, but I do wonder about having retired judges filling in, pinch hitting, and how that meshes with accountability, and that those retired justices or judges will not be standing for a vote of retention. They're basically, you know, come and go. Any comments on that?
Mr. Chairman, I think that is a very valid concern. For one thing, because I think, as everyone knows, all the judges are subject to retention elections, and if the people don't like them, they can vote them out. They could not vote out a retired judge. Two things. One, I think if somebody fills in for a week, it's still that local judge who's accountable, just like you would be for any substitute. As we develop our plan for using retired judges, I think what your comment, and we've heard this from other people, what we can look at doing is including an evaluation system for those judges, and just so that we know if there's dissatisfaction, we won't use them.
Committee, any other questions? Senator Schuler?
Thank you, Mr. Chairman. Just to piggyback on that, I had the same idea as you, co-chairman, but I also want to take it one step further. These judges that are filling in now, are they doing it on a volunteer basis or have we funded them?
Madam Chief.
Senator Schuler, Mr. Co-Chair, we have a small pot of money, I think about $50,000, that we have earmarked for quite a while to use retired judges when, in the past, it's only been for emergencies. So like a health emergency, if we need someone to go in and help. So we pay them. What we pay them is the pro rata hourly rate for a judge. And that's one of the problems. One of the things that we're looking at is the possibility of doing something that they do in Idaho, and I believe also Montana, where they provide it, and the legislature enacted this law, which provides enhanced benefits for retired judges, and they commit to so many hours a year.
Representative Oakley.
Thank you, Mr. Chairman. Good morning, Chief Justice. I'm interested in this court navigator program that you talked about. Is that just, so a couple things about that. Is that a position or system that other states are doing? Is that, you know, that we have a pattern, and I'm interested in funding. You said like the pilot, there's a projected, I guess, to be a pilot in Natrona. So if that position is funded and how, and a little more about that.
Madam Chief.
Representative Oakley, Mr. Co-Chair. There are a number, in fact, most states have some kind of navigator program. They have different names. So yes, there are models, and our Access to Justice Commission, which is chaired by Justice Boomgarden, has been studying and gathering data and doing a lot of work on this for the last year and come up with this sort of model that we think would work in Wyoming. Funding, always an interesting question, and we very likely will be coming to the legislature to look for funding for that position. And that may be also part of the Administrative Office of the Courts request, is to have someone to oversee not just the problem-solving courts, but the navigator program as well. For now, if this Casper Navigator plan isn't fully baked, one of the things we're looking at is working with the Casper College paralegal group, and so maybe for credit. I don't know where the money's going to come from just yet, but eventually we'll be asking you.
Further questions? Representative Shestak.
Thank you, Mr. Chairman, Madam Chief Justice. I was thinking a little bit about the problem of judges taking vacations and having to get coverage to be able to do that. I understand that the retired judges is one possible solution. To what extent could technology help with this? I know that I hate Zoom. I hate Zoom meetings. I hate Zoom trials. Probably are worse than Zoom classes that I'm used to doing, but in a pinch, they can work. So to what extent is it possible to use technology to get another judge from another county to cover things by Zoom and not have to have a lot of travel expenses, things like that?
Madam Chief.
Representative Chestick, Mr. Co-Chair, we already do a lot of remote hearings, not so much trials. Trials are complicated to do by video, but lots of hearings. And that has been a great boon to helping out. It seems probably to be used more in circuit court because those kinds of proceedings are shorter and more simple. But in district court, we use video extensively as well. The thing is, there still are many kinds of hearings that require the presence of, especially in criminal cases, of the defendant. You know, usually I would say for civil cases, if a judge is on vacation, they just will schedule it at another time. Criminal cases come up fast and furious, and so do family cases, like shelter care hearings have to be held in 72 hours. Those kinds of things you could do remotely, but it's more challenging.
Mr. Co-Chair.
Mr. Co-Chairman, thank you. Madam Chief Justice, thank you for being here this morning. Appreciated, you sharing several very good points. I guess I would ask this, as we go along today and on through the interim, as if you recognize a spot where the Judiciary Committee can be of help to you, other than just backing you up when you go to our friends on appropriations. We sure would be interested in that. For example, I'm going to be looking today about through the Navigator program, through the Rural Attorney program. If some of this takes statutory help, please don't hesitate to wave the flag and help us know how that might work. And I'd sure appreciate that.
Madam Chief.
Mr. Co-Chair, I appreciate that offer very much. I also appreciate the opportunity to just keep you updated on the things that we're working on, so that when we do come with a statutory change or a budget request, you'll already kind of know what we're trying to do with it. So I appreciate your time and attention.
Okay, one more. Representative for Vincent.
Thank you, Mr. Chairman. The kind of just off topic from these,
But in your State of the Address, we talked about juvenile justice. And I'm wondering if the court has done anything in regards to that realm, or if there's things that the judicial branch is looking at in the next year with their strategic plan or anything related to that, just to kind of bring us back to, that's something that I think all the branches of government have talked about, that I'd kind of like to see followed through. So just any updates on that?
Madam Chief.
Representative Provenza, Mr. Co-Chair. Yes, well, so juvenile justice is another priority. And there are a couple of things that we're doing with that. First of all, we have the Children's Justice Project Advisory Board, which in fact, Judge Snyder is the chair of. And so they are looking all the time at how to operate, especially the abuse and neglect cases, more effectively. And just keeping the data on that has been really useful in terms of time to disposition. The other thing is, as you know, treatment courts are going to be transferred to the judicial branch because of legislation enacted earlier this year. That will happen in July of 2024. And I think there's a lot of potential for juvenile treatment courts as well.
Okay, thank you very much. We'll continue through the agenda. Are you
Thank-
going to stay with us, Chief, or are you going to?
I will. I'll hang around for a little while. Thank you.
Very much.
Good morning, Mr. Chairman, Mr. Co-Chairman. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. I am here initially, I've got one more topic to talk to you about today, but initially I'm here to talk to you about the staffing for the Administrative Office of the Courts. So the Administrative Office of the Courts is the office that I oversee. We have right now 37 employees, I believe. What we do in the administrative office is we provide administrative support to all of the courts statewide. So that includes things like fiscal and HR. We do budgets for the courts throughout the state. Our judicial branch budget is done within our office. We provide HR support. So things like onboarding, offboarding, leave, and any HR issues that potentially come up throughout the state with employees. We provide legal support, which is always a little bit surprising. I think people are surprised that our judges need legal support, but they have day jobs and there's a lot of legal work to do. We do all of the judicial branch contracts within our office. So that includes things like e-filing, case management system. When we contract with vendors, those contracts are negotiated, drafted, all of that within our office. We have an education division. So as the chief said, one of the things that we do pretty well, the judges are required to get so many continuing judicial education credits every year. So our education division helps with that. We also provide education to clerks throughout the branch, right? So when we have issues in courts or things that we need to train them on, that is done through our education division. We have an IT division that provides all the technology support. So you see these lovely screens here. We have those in every courtroom across the state, and our IT division supports all of that technology. So it does allow for things like remote hearings, which has been incredibly helpful for people to access the courts. It was especially true during COVID. And then we also have a software applications division. So what those folks do is they roll out the systems that are used branch-wide. So you heard the chief talk about a case management system. That case management system was implemented and trained and rolled out by our staff. E-filing system, that's also trained and rolled out by our staff. We have a public access system. We have e-citations, and we have a number of other branch-wide systems that are implemented, maintained by our staff. So we provide all of that support for 318 full-time and 25 part-time employees. So 37 people to support all of those folks throughout the branch. One of the things that was done during, over the last year, Chief Justice Fox talked about the task force and the work that task force did. And one of the things that the National Center did for us, as they facilitated those conversations, was provided a report and recommendations to the branch for how it could become better, more effective in the work that it does. And one of the biggest takeaways from that report was that our administrative office is substantially under-resourced. We are providing a lot of administrative support, but the truth of the matter is we should be providing a lot more to our judges throughout the state. The other thing that has come to pass over the last few years, which is new for the judiciary, is that it's much more engaged. So Chief Justice Fox talked about the fact that judges historically have been used to staying on the bench and making decisions and not kind of engaging in the other things that are happening in the community. And the fact of the matter is that's no longer possible. We have self-represented litigants that are coming in the court every day. We have people with mental health issues that are coming in the court every day, substance abuse issues, all of those things that the judges see every day affect how they do their jobs. It creates more of an administrative burden for them. And that's something that we should be able to assist with. Right now, it's incredibly difficult with the staff that we have. So some of the things that I think that I wanted to talk to you about today that we have seen over the last, I would say 5 to 10 years in the administrative office. So the administrative office was, it came to be in Wyoming right around 2000. And so it's very, very new. It's a very new office. In other states, they've had an administrative office for 50 years, 60 years, 100 years. We've had ours for a little over 20. So we're very young. In that time, we have grown. The administrative office has grown, but it hasn't grown commensurate with the workload, the administrative workload that's come down the road as we've moved forward. So some of the things that have increased the workload for our staff, one of the big things is data. And I think you all know this is a huge issue. We are constantly being asked for data from the legislature, from the public, from people who are doing research in the area of the judiciary. Representative Provenza, to your point, one of the things we're working on right now is working with DFS on a data feed for their new system. And that has become a lot. I mean, so there are 3 or 4 agencies that we provide data feeds to, or we are working on data feeds to them because we are required to statutorily feed them certain pieces of information. So that takes a lot in terms of creating that data feed, training the clerks how to enter it, ensuring that it's accurate when we send it along so that when those agencies are using that data, we know that they get good data. That's a big lift and something that has become much more prominent over the last few years. There's an increased public demand for access to court records. Again, this is a good thing. Transparency is always good. We want to be transparent, but the immediate access is hard, and there are a lot of confidentiality issues around many of the documents that are filed in court. And so while we're working toward a place where we can have remote public access, which is what everybody wants, we do have to be very mindful of where those documents are, those confidential documents, what kind of information is being shared remotely, and ensuring that that privacy is maintained. So that's another big piece that we're working on now. We have increased regulations, ADA, court interpreters, the Fair Labor Standards Act, the Family Medical Leave Act. All of those things are things that our office manages for the courts throughout the state. Again, a burden and one that the judges shouldn't have to deal with on a day-to-day basis. That should be done in our office. We have, along with all of the technology that we have in our courts, including the courtroom technology, the screens, and the court automation systems, e-filing, case management, those all come with vendors. So people that we contract with to provide those services or those pieces of software, vendor management is hard. I'm sure you hear that from a lot of agencies, but making sure that our vendors are doing what we contracted with them to do is a difficult task, and it can be very onerous. And that has increased substantially over the last few years. And so all of these things that I've talked about today, don't even consider the new strategic plan, right? Those are just things that we have on a day-to-day basis in our office. And so looking forward, as we want to implement that new strategic plan and make the judiciary better, more effective, one of the pieces that we are going to need is more resources to get that done. So some of the programs where we will be looking at more staffing. I think the chief mentioned a few already. One is the court navigator program. Initially, when we pilot it, it's unlikely that we will have a dedicated staff person at that point. I don't know what that looks like just yet, but at some point we will need somebody who can oversee that program, provide the training, make sure that the court navigators are doing what we need them to do out in the courts. Treatment courts are another piece that will need probably additional resources. Treatment courts in the diversion program that we'll talk about here in a little bit. Both of those, I believe, will be improvements to how we deal with people with substance abuse and mental health issues. But again, somebody to help oversee those programs, making sure they're moving in the right direction. That kind of staffing will be needed at some point. A public information officer, as the chief mentioned, that is, again, a big lift that our office does right now. I actually do most of the outreach for the administrative office and the judicial branch from time to time. Having somebody who is a dedicated public information officer who can regularly talk to the media, provide quick feedback, that would be very helpful to our team. So those are a few of the pieces, and one of the handouts that we have provided you, I think it's 6-04, has a number of bullet points on things that we could use in the administrative office. So additional staff to help with the rollout of the court case management system and e-filing systems, a grant writer. There are a lot of agencies that have grant writers. We don't have one. That is done all through our fiscal office right now. Enhanced services to self-represented litigants. We talked about that a bit. Managing the day-to-day human resources. So we have 2 people in our office who do all of the human resources work for our office, basically. I can tell you that is not enough to do the day-to-day and then also provide the kind of support that we need to provide to the judges. So one of the things in the strategic plan is providing education and support around vicarious trauma. So I think you all talked about that a little bit yesterday. It's something that the judges deal with every day. They are seeing sometimes the very worst of humanity. And so providing them with that kind of support and education is really important. We've got conferences that we manage every year, having some support around that. Talked about treatment courts. And court services, just providing somebody who can be the person that the courts reach out to for various issues. The court interpreter program, an ADA coordinator, when you have somebody who comes into the court and says, I am deaf and I want to be able to understand what's happening in this courtroom. So somebody who can help facilitate that and ensure that it actually happens, again, so we can maintain that transparency in our court. And I think that's, I don't want to say that's it because it's a lot. But I also want to be mindful of your time. So the things that I think these things will help just statewide, when you're thinking of how is this going to benefit the state, increased assistance for self-represented litigants. That's always something we want to provide. Access to the courts. It's what we do. And having somebody who can help them navigate that system will be incredibly helpful to the citizens. an increased focus on collaboration with the other branches of government when it comes to mental health and substance abuse issues. The governor just had his mental health summit, and I think we want to assist with whatever we can to ensure that how those people come in and out of the court system is effective, and that we're not just recycling them through over and over in the court system. Increased transparency. We always want to be transparent, and things like providing a remote public access system will help with that. And then increased access to the courts. We already talked about that, but the technology that we have throughout the state really has provided an increase for citizens who need to access the courts and cannot do so just because we live in such a rural state, and it's so far between places. So some people can't get to the courthouse, and that increased technology really has assisted the citizens in having that access. So, Mr. Chairman, I think that's all I had to talk to you about today, but I'd be happy to answer any questions.
Committee, any questions? Senator Furphy.
Thank you, Mr. Chairman. Now, let me explain. I'm a banker, not an attorney, so some of these questions may be out of line, but how backlogged is the court system now? I hear that occasionally from constituents that it takes a long time to get into court. Do you have any input on that? Thank you.
Ms. Butler.
Mr. Chairman, Senator Furphy, I think it depends on the court, but generally, I don't believe we are terribly backlogged. And part of that is thanks to new judges that we just got, not this 23 session, but in 22. There were 4 new judges, I believe, that were three new judges. So in the locations where we had a very high workload at the district court level, though those new judges are not entirely in place. There's one in Campbell County where we have to find a suitable court space for them, but we have a new judge in Uintah County, and then we have a new judge in Natrona County, and both of those locations had a very, very high workload. So I think that is helpful in decreasing the time. One of the pieces that I think is always good to know is there are cases that are prioritized. So we have criminal cases, we have juvenile cases. Those both have timelines attached to them of when we have to get those done. They are priority cases. And so when the judges see a lot of juvenile or criminal cases coming along in their docket, Title 25s is another one, they have to get priority. So sometimes that means some of those civil cases are bumped farther down the road, unfortunately. And that is just the nature of those kinds of cases that need a very quick resolution.
Co-chairman.
Thank you, Mr. Co-Chairman. Ms. Butler, I want to go to the administrative piece. I really appreciated you giving us the rundown. If nothing else, I think it's really helpful to put it more prominently on the radar screen. I never sat and thought about all of the administrative detail that must be involved for the judicial branch, and probably assumed along the way that, yeah, we had people in place to do that. Clearly we don't. And so my question to you is, it seems to me that a couple of these positions that you pointed toward are not going to take a law degree. Is that correct? I mean, can you speak to the level of folks you might be looking for?
Ms. Butler.
Mr. Chairman, Mr. Co-Chairman, the vast majority would not require a law degree. So we have in our office right now, I have a law degree. We have our chief legal officer who is legally trained, and then we have one more attorney in our office, a staff attorney. This last session, we got another position for a second staff attorney, so that will be incredibly helpful. But those are the the positions in our administrative office and we have our education, the head of our education division is also an attorney. So we have 4 attorneys right now. We will have 5 in July. So the vast majority of our staff is not, they do not have law degrees. They are doing the administrative work. So they understand how the courts work, but they don't have, legal training through a law school.
Follow.
Thank you, Mr. Chairman. So, the administrative work piece, that's helpful. I'm just trying to get a sense of the navigator piece versus the administrative piece. I guess the navigator thing is a little bit different, and it's your thought that we start with just with a pilot program. Does that make sense? And I think I heard you say Casper. Would this be a position that we would need to help with, and would it be a temporary, or hopefully they would stay on and then maybe build that out across the state? What's the vision?
Ms. Butler.
Mr. Chairman, Mr. Co-Chairman, I don't know that we have it entirely fleshed out yet. Initially, yes, it will be a pilot. And again, it's just to ensure, it's like a proof of concept, right? We want to make sure that it works, that it's helpful, also to work out any tweaks before we roll it out more substantially statewide. So Natrona County is the thought right now. I don't know how we will staff the pilot yet. There are a couple of different options, and Chief Justice Fox mentioned possibly working with the paralegal program at Casper College. I think that's a possibility, but that has not been entirely fleshed out yet. One of the things to always keep in mind is eventually, if it does expand, there will be positions involved that will be actual court navigators on the ground. And again, what that looks like, we don't know quite yet. But the other piece that comes with that is oversight of that court navigator program. So providing them with education about here's what you can and cannot do. Also ensuring that they are towing those lines, right? So there's some not only administrative load just in the navigator program itself, but also in making sure that program is working the way that it should.
Just one final question.
Okay, one more.
Just one more. So thank you, Ms. Butler. Appreciated that. It just seems to me that the judicial branch nationwide is just more prominent these days. That's a good and a bad. And I'm just wondering, can you speak to the impact at the Wyoming state level? Have you seen an increase going specifically to the information and public relations piece? Have you seen an increase in the requests for information, in the demands from the public, demands from the media? Can you speak to that for me?
Ms. Butler.
Mr. Chairman, Mr. Co-Chairman, it's entirely anecdotal, but I do believe we have had an increase. Some from the media, a lot for data. People want reports. And again, that comes from a variety of places. We have other executive branch agencies who want data from us. We have people, as I said, who are doing research throughout the United States on how the judiciary works in different states, and we will get those requests pretty often. Public interest groups request information pretty regularly. We do get requests from the media from time to time. I've had to do a few interviews. I know Chief Justice Fox has had to do a few interviews, and I shouldn't say I had to. They are good. We need people to know what the judges do in the state. It's important work. So yeah, I think having somebody who could help coordinate all of that would be very helpful.
Ms. Butler, you mentioned an ADA coordinator. I think many of us were under the impression that the staff attorney position that was approved for July 1 was going to be your ADA coordinator. Was I incorrect in that?
Mr. Chairman, no, we will, the ADA coordinator, at least initially, will be that staff attorney. And one of the things that we learned through the National Center is many states, many administrative offices have what they call a court services office that really is kind of the hub for the courts throughout the state. So that's the people who help you find an interpreter. Potentially that ADA coordinator could shift depending on the legal work that comes down the road. It could stay with that new staff attorney. There will be more than enough work for a court services person if we get one, and a staff attorney in our office.
Thank you. Senator Schuler.
Thank you, Mr. Chairman. I had a frog in my throat. We'll clear it out. My question is on the, Ms. Butler, the treatment courts. I'm just kind of wondering if you feel like you're set up so we can make an easy transition. Are there issues that you see coming down the pike with that? I think it was one of the really good things we did, because I think it needs to be there. But what do you see in terms of issues that we might have?
Butler.
Mr. Chairman, Senator Schuler, I think we are in a very good position. One of the things that we received through ARPA funding during this last session was money to help with that transition. So what we have done is we've hired a consultant who's worked with treatment courts nationwide to help us determine basically all the things that we need to do to ensure that smooth transition. One of again, this is going back to our staffing. Our chief legal officer is actually leading the charge on that, mostly because there's nobody else to do it. So he gets to do it, and he's doing a wonderful job. But yeah, so we will continue to work with that consultant. We have a committee that we're working with right now on treatment courts. We're continuing conversations with the Department of Health to ensure that smooth transition. We will provide you all with a report, I believe in August of this year, kind of outlining what we anticipate that transition is going to look like. And I think by that time, we should have a good idea of how that will all work.
Senator Case.
Thank you very much, Mr. Chairman. Ms. Butler, good to see you. Yesterday, we had quite a bit of testimony from parents and grandparents about the issue of interfering with custody and even abduction of children by parents in a relationship. And their testimony, I'm going back to your testimony about how the dockets are and whether you can get something done. Their testimony was and it was all anecdotal, please understand me, but in cases, for example, where a parent had already been found in contempt of court, it still required months and years, potentially years, to get back into court to get something done where a parent is violating the terms of the custody relationship. It's pretty heart-wrenching testimony overall. And I'm kind of trying to look at that and then your testimony that the courts seem to be pretty well caught up. And I understand that those are civil cases, but some of these where one of the parents is actually already in contempt, that was really shocking to me that wasn't a higher priority. So I'm trying to figure that out.
Ms. Butler.
Mr. Chairman, Senator Case, I can't speak to specific cases, but so generally the courts, the judges themselves are not prosecuting cases, right? They are deciding what is before them. And so, and true, I think the testimony yesterday was 45 days to get into court. And again, I'm not going to speak to that specific case, but what would happen generally is, somebody would file a document. So parent would file a document that says, I need an order to show cause because parent is not complying with the custody order. And I think the judges try to get those on the docket very quickly. I can also tell you that, again, and the judges are in a very difficult position in those domestic relations cases, and there are always two sides to every story. And so, I think they try to schedule those as soon as they possibly can. But again, there is no, timeline of when they have to. And there are other cases that will always take priority, unfortunately. And that is again, because, you have a juvenile case where a kid's been taken out of the home, or you're running up on speedy trial and you have to get that case to trial. So there's some pieces that limits to the timing of how quickly somebody can get into court in some circumstances because of the dockets, just the nature of the courts themselves. And I do think that's an unfortunate reality of the cases that come before the courts, as you can't always get into court the same day.
Nothing more. Thank you, Ms. Butler. Do you have another topic that you want to move to, or?
Mr. Chairman, if you'd like me to, I can talk about the diversion topic. I think the next one you have on your agenda is court security. So if you would like us to do musical chairs, we can. Justice Fenn will be presenting on court and judicial security.
Very good. Let's have Justice Fenn come to the table. While we're changing chairs, I just want to take a moment and recognize former Representative Kenner has joined us this morning. It's always great to see him in good health and joining us again, and wish you were still with us, and hope you're enjoying your retirement. And Representative Pendergraph is back there in the back too. I didn't see him. Thank you. Always good to have members of the legislature join in our committee, and glad you're here.
I am John Vinn. I'm the junior justice on the Wyoming Supreme Court. Here for me to be here in Sheridan, Wyoming, where it's still home to me, so to speak. And I had a beautiful day out on Soldier Creek Ridge, hiking with my wife, and reminisced on what a beautiful place Sheridan is. So it's great to be here. I'm here this morning to talk about court security. I am the chair of the Court Security Commission, and we have been busy over the last year. I have kind of three areas I want to visit with you about, just kind of bring you up to date on what we have been doing with court security. I'm prepared to share with you some statistics and some examples of some of the concerns that we have. The second area is there are some legislative changes that I would propose that you consider. And finally, I want to focus on where we see we're going in the future with respect to court security. As I've indicated, we have been busy. We have a state court commission that oversees county court commissions. And about 15 years ago was when this process was created. And the legislature was very generous and funded it well. And we did a good job, I think, of installing hardware throughout the state, electric door locks, hardened benches, cameras, a lot of metal detection equipment and assessment of the courtrooms. And that has all been done and accomplished. And most of the fairly easy things hardware wise have been done and have been in place for several years now. It seems to me that at this point in time, training and manpower are the real weaknesses. The human element with it respect to the court security is the challenge now. We have seen a lot of turnover within the judiciary and also within the law enforcement, the sheriff's office that provide the security for the court rooms and courthouses. And I'm just amazed at how that training is so important. And so we have focused on that. I have spoken to the sheriff's agencies. I've spoken to a number of county commissions. We have got the Law Enforcement Academy back up, and they have a 40-hour week-long training for court security officers that was sort of interrupted because of the pandemic and other things. That was full. There's a waiting list. And so we're happy to get that training back on track. And the other thing that we've learned is just kind of the manpower of manning these stations. Some counties are very good. Natrona County, for example, Laramie County, you go through a metal detector, there's 2 or 3 deputies there. They're making sure that things are safe. Other counties, there's nothing. And so you have this hardware and equipment and nobody there to man it. And the presence of a law enforcement in the courthouse and in the courtroom is just paramount to protection and order. My experience here in Sheridan is we have one deputy that covers the entire courthouse. At times we have 3 courts going at one time. Certain days, the judge from Buffalo is here, the judge from Sheridan, and the circuit court judge. And so he's going through all 3 areas, as well as the rest of the courthouse he's responsible for. And he does a wonderful job, and he's really good at it. He's kind of the right person for it. But it's just an example of the expectations that we're calling upon our sheriff's departments to protect the courthouse. And I say courthouse because it's beyond just a judge sitting on the bench. It's the county assessor's office, the treasurer's office, the clerk's office. Those are all areas of concern and responsibility that we are concerned with. So our focus is to really get training for those individuals and promote the commitment of resources through the sheriff's departments to man those different courthouses, and we're going throughout the state to do that. With respect to incident reports, we receive approximately 40 incident reports a year. So that's a little less than 1 a week. And some of those are minor instances and some of them are very serious instances. And we've seen a dramatic increase in those reports. And I don't really know all the reasons for that. Part of the reasons we've been out there shaking the bushes, so to speak, and saying, getting the incident reports in. So I think that we've created some of that ourselves, but also I think the pandemic had so many impacts in society. And one of those is the courthouses were kind of closed down. We did things a lot remotely, and now we're coming back on board. And I think the sentiment nationwide and here in Wyoming has changed a little bit. There's a little bit more vocalization of discontent. And so I think there's a lot of reasons that we've seen a fairly significant uptick in the incident reports in the past few years, but we are taking it very seriously. Court security is nothing new, though, and it's not their problem, it's a here problem. Those of you that have had the pleasure of growing up and living in Wyoming, as I have, way back in 1977, in Evanston, we had a bombing of a family that killed that attorney and his wife and child. We've had an arson here. The county attorney's office was set fire here in Sheridan in 2014 by a disgruntled defendant that thought by starting as I understand it, that thought by starting the county attorney on fire, it would delay his case. And he's now had been incarcerated for probably the biggest part of his life. But those are scary events. We've had instances in my experience as a district court judge. I've been confronted in a parking lot. I have had litigants show up on my doorstep on Sunday morning. I've had, when I was a district court judge, my kids were still in school. I had one litigant that was making credible threats. I notified the school. I had a picture hanging there to make sure they didn't go to school, and that individual ultimately took his life. I didn't do it in a dangerous way to others, but he was struggling. And I think that's one of the areas that we see. One theme that we're seeing in some of the instances, the mentally ill within our judiciary. We have a number of mentally ill people that are showing up on doorsteps of judges or confronting judges in parking lots or threatening judges. The makeup of our judiciary has changed. We have younger judges with families, female judges. Several of the female judges have reported to me that they have threats of sexual violence against them, and they're concerned. Judges work long hours oftentimes, and they're going out in dark parking lots by themselves. And I can tell you my own experience. I'm a big guy. I always felt like I could take care of myself, and I was confronted in a parking lot in Johnson County. Fortunately, those of you may know, he's now Sheriff Odenbaugh. He was the deputy at the time. He's a big guy, bigger than me and tougher than me. And I was so glad to have him behind me. And he saw it happening out of the window and came down and diffused the situation. And I was sitting there with a briefcase in my hand, going to my truck at the end of the day to come back to Sheridan. And I was so grateful. That's the first time in my life that I wasn't in the front of the line for a fight. And I was really glad to have that guy behind me with a gun to protect me. So even myself, who I've always felt pretty comfortable, I was really glad. And I think that the makeup of our judiciary now is such that we need to do a better job with respect to off-site protection of our judges. We have looked into court security or security systems for our judges at home. And I'm not here to ask you directly for any funding for that, but I would like to plant that thought in your mind. We don't want to get in the court security business or the home security business, but there are a number of judges have asked for some assistance, and we haven't been able to provide that. I think anecdotally, about 30% of our judges have pretty extensive home security systems, and they've just done that on their own. This home security systems are somewhat unique in that what's available in Sheridan might be different than what's available in Natrona County. And so there's kind of a hodgepodge of systems that are out there, and some of them come with just a simple camera. Others have monitoring and will connect to law enforcement, and they charge a monthly fee. But I hope that at some point in time, there may be some consideration to helping offset some of those expenses for the judges. With respect to legislative issues, there are three areas I would ask for some legislative change or consideration. The first one is threats to judges. We have a statute, 65305, that makes it a felony to threaten, influence, intimidate, or impede a juror, witness, or officer. And the question is what does an officer mean? And it could be as simple as just legislatively defining that to include judges, staff, family, people at the courthouse. I'll leave it up to you folks to set the policy with respect to that. But this statute, to my knowledge, has not been used much. And I don't know exactly why. I know that we had some pretty serious instances in Natrona County, and this statute was not used to pursue that. I think that the individual involved had some mental illness, and that might have played in part of it. Also, what is an officer? I mean, this was a mentally ill person who had been stalking a judge. The investigation revealed that before he confronted the judge, he had scoped out the judge's home for over several times. The judge would have liked to seen a prosecution out of that, and it didn't happen. And part of it, as I understand it, was this statute was really not very well crafted as to a judicial officer. He wasn't threatening to try to impede an outcome of a case. He just didn't like what happened and threatened the judge. So reworking that statute, and you've got a memo that talks about what many states have done. I won't go into that in any detail unless you'd like me to. But we would ask that you put that on your topics to consider for legislative change. The next one is with respect to defining the sheriff's role in providing court security. Right now, we have a statute and some rules that say the sheriff shall attend court. And that has generally been applied, that the sheriff will provide security, but it says attend. It doesn't say provide security. And there are some counties where that has been a little broader interpretation in other counties, and issues as to whether or not they should be attending all hearings or just the hearings that there's a criminal defendant involved. And so looking at that, I think would be something that would be worthy of your consideration. It's not a highest priority for me. I think the other one is a higher priority because I think most sheriffs are taking their responsibility and doing a good job, but clarification of that role might be helpful. And the final area of consideration legislatively that I'd like to think about is just personal privacy protections. You know, we live in this electronic world now where I can go to the county assessor's website. I did it. It took me less than 5 minutes. I know where my home is. I know where my home in Sheridan is. I know where my home in Cheyenne is. And it took less than 5 minutes to find that out. I understand most assessors, if we go in and request them not to put that on the website, they won't put it on the website, but it's still public information. If they go down and ask for it, they can get it. We've also been encouraging judges, you know, there's all kinds of these people finder websites. Most of them have an opt-out option, but you have to actively ask for that opt-out option. And we have been encouraging our judges to do more of that. Certainly keeping our profile off of some of these websites is appropriate. And that's really, I think, the biggest new wave I've seen is confrontations outside the courthouse, at home and other places. And I don't have a lot of good solutions. I live in Wyoming for a reason. I live in Wyoming because people do know me. They know where I drive. They know when I'm in the grocery store. They know where I live. And those are benefits of Wyoming, but it's also a detriment of Wyoming with respect to court security. I've seen it myself. In Cheyenne, I'm a little more anonymous in my personal life. In Sheridan, I wasn't. But any help that you can do with respect to that area, I think would be very much welcomed by the judiciary. And that, I guess, covers my presentation. I'd be happy to entertain any questions you may have, and I've got lots of war stories I'd be happy to share with you, but I will tell you we're taking it very serious, and I think we've seen an uptick, particularly in offsite confrontations and concerns with respect to the litigants and judiciary.
Thank you, Justin. Representative Jennings.
Thank you, Mr. Chairman. Judge Finn, good to see you home.
Yeah, thank you.
And you presented some quandaries here a little bit for me. Probably most of us up here have run into disgruntled constituents. And so when you talk off-site like that, and in the courthouse, I get it. I understand that and very supportive of that notion. But where does that come? Because pretty soon we make classes of people, and you as a judge of all people see this, I'm sure. You know, offsite, where do we stop? Do we protect judges, but we don't protect legislators? Do we protect, pretty soon, do we protect all the teachers? What life is more important than the other? And we want them all to be protected, but there's only so much. So without making one class of people, you see what I'm getting at there, Judge? Could you speak to that a little bit?
Chair and Representative Jennings, that's the big quandary. I mean, we live in Wyoming for a reason, and we live in Wyoming because we're a small place. We know our neighbors. People know who we are. I think some consideration, perhaps case by case security is a possibility. So if you got a particularly controversial case, maybe some added security. Many other states, and I'm not advocating this, many other states, and certainly the federal system, they provide much more security for their judges. I don't think that, I'm not asking that. I think training for the judges, the other area that we haven't taken a specific position on, but we're sensitive to, is firearms. Our position is that's up to the individual. However, if they are going to have a firearm, we want to facilitate them being trained with it and knowing how to use it. I grew up in Wyoming, and I've seen things change. When I was in high school, opening day of hunting was a holiday. Hunter safety was part of the curriculum. And if somebody wanted to shoot up the school, many students could just run out to their pickup and grab a rifle. And so things have changed and we've seen it. In 1993, we had a school shooting here in Sheridan, Wyoming. So we are not immune from these concerns. I think training is probably my suggestion and approach, and we are actively pursuing that. In fact, this week we're having a specialist come in and train the district court judges, and next week circuit court judges. We're also having a judge who was shot in her driveway with her child from Texas that survived. She's coming to speak to the district court judges and circuit court judges to just help with that awareness. I think that when these issues are alerted, the sheriff and police department are providing the security. The challenge is it comes from all, a lawyer is the one that shot the federal judge in New Jersey. A very wealthy, disgruntled litigant shot a judge in Reno. It's mentally ill, it's the domestic relations, it's the criminals, it's the ones that we don't have any idea. It's not the scary guy with tattoos and the beard hiding behind the bushes. It's the guy that you would never guess, the arsonist here in Sheridan, graduate mechanical engineer, highly educated, well employed. So I wish I had a better answer. Our focus, I guess, is training at this stage.
Representative Chesty.
Thank you, Mr. Chairman. Justice Fenn, thank you for being here. I did take a look at the briefing memo on Wyoming Statute 6-5-305 and the intimidation statute and the question that has been raised about whether that should be interpreted to cover judges. And because judges aren't specifically listed in the statute, but it does cover officers. And to me, the highest officer in the courtroom is the judge. So I think it's pretty easy interpretation to say the officer has to include the judge. If it doesn't include the judge, who else could it possibly cover? But I do understand that you believe that we need to have some, or maybe there's a suggestion that we should clarify that to include judges specifically. My concern with that is I teach law. I'm a law professor, and I teach statutory interpretation, and I teach how to interpret statutes about that. When you have a list, the more specific the list gets, the more it excludes things. And if we start putting in specific language, then that narrows the scope of the list. There's always a catch-all at the end and things like that. But when you have a list that's pretty specific, you get the catch-all catches fewer things. So I'm a little concerned if we start trying to predict every possible officer who might be considered to be an officer, we're going to miss somebody and exclude somebody. So can you give me some thoughts on whether we really need to amend the statute, or do you think relying on the good offices of the courts to interpret the statute might be sufficient?
Chair and Representative Chestik, we do not have any authority in Wyoming with that interpretation currently. Point one. Point two is this statute has not been utilized very much, and I don't understand entirely why that's the case, other than I think other parts of the language about bear with me for just a second here. Influence, intimidate, impede an officer has been a little bit troubling, I think, for prosecutors, because many of these confrontations aren't to maybe they're to intimidate, but they're just kind of I think this is really written for jury tampering. And so that's why we set out in the memo the many different states to look at it from different directions. And I leave that policy decision up to you, but I think right now we're not seeing this utilized. And specifically, it came to light in an instance in Casper where the judge, this person came to the judge's home multiple times, confronted him, and the judge called me as a security commissioner, says, "What do we do?" And I says, "Well, we've got a statute." And he goes, "They're not, the prosecutor won't pursue it." And so I would like to see it changed. That's my suggestion. I would like to see it include specifically judges and family members. I understand some concerns. I think it's broad. I think you could make it broader. I think you could, I'm not asking you to reinvent the wheel. You could rob from some of these other statutes. I think specifically saying a judge, specifically saying at home or outside the courthouse and is included. There are some things there that would be helpful to maybe enforce it. You know, I try to walk this very fine line. I don't want to tell you, you know, I want to respect the division of the branches. So we kind of highlight the problem, and as you go forward and work on it, I think we'd be very happy to give you input. But as soon as I start interpreting it for you and telling you, then that, you know, my role as a judge is muddied. And so it's a very fine, purposeful line that we try to stay on the right side of. So I'm kind of ducking your question a little bit.
Representative Jennings.
Thank you, Mr. Chairman, Judge Finn. So back to the part of security, I was glad to hear you say that there's training and stuff like that that's available, and all of us, I mean, you see it all the time in courts that we need people to take more self-responsibility and take care of things. I mean, all of us are doing that or want to do that. But I'd like to go over to the side that says, or as a question to you. So when this is broad, my colleague says maybe broad enough, and you would like to have it a little broader or something like that. Does out of the courtroom, would that constitute contempt of court to intimidate somebody at their home, a judge? Or, I mean, it seems like there might be some other criminal levels that are available there also. And if there are, I mean, just like you said, we have this statute on and we don't see any prosecution of it. And we had that same thing the other day. There were laws on the books about contempt in the case that was Senator Case spoke about. And they're not being used. They're not being prosecuted. So if we write something and then it's not prosecuted. So my first question there would be, does that not rise to a level of criminality that ought to be prosecuted?
Chair and Representative Jennings, I don't think it really fits in contempt. There are different types of contempt. There's direct and indirect contempt, or civil and criminal contempt. And most of the contempt that we see is civil in nature. It says you will do this or here's a consequence. And our authority in that area is there's direct and indirect contempt in the courtroom. If somebody in front of the judge does something inappropriate, you can say, I saw it personally, you're in contempt of court. There's indirect contempt. It's something happened between mother and father outside the courtroom in violation of court order. They have due process rights. They come in and they have a little trial on that issue. And so this is outside of that. I mean, the judge is the victim. And I don't think contempt is the answer for this. It's not typically in a courtroom. It's not within the powers that the judge is exercising to control the courtroom and honor his or her orders. They're a victim of somebody that arguably is a dangerous, threatening person, more of an assault. So I don't think contempt fits here very well. As I sit here today, I think that I'm going to put on my agenda to go talk to the prosecutors. I'm going to highlight this to them and say, I'll ask the question as well. Why aren't we using this? Why hasn't it been used? To my knowledge, I've been in the judiciary now for just under 20 years. I'm not aware of a single prosecution in this area for courts, security issues. So I will be better prepared next time. I intend to talk to the prosecutors and find out more why.
Let's talk to one now. Representative Oakley.
Thank you, Mr. Chairman. Through this discussion, I guess I would just weigh in that I don't think this is a great statute for that. And I think, influencing the words, the verbs here, influencing, intimidating, impeding a juror, obstructing justice. I think that's similar to what you said, like, just because you're a judge doesn't mean you get to hold somebody in contempt, right? I mean, we understand that that's not a court order, but so obstructing justice, I don't think that fits, but I also think it's quite simple. I mean, well, we have to pass a law, but I mean, I just wrote down threatening, intimidating, or harassing a judicial officer. I mean, and I like criminal statutes that are very direct like that. And we talked about, broad or narrow. I mean, is there anybody that wouldn't understand if we had a statute that threatening, intimidating, or harassing a judicial officer, a district court or circuit court judge is a crime? I mean, it seems to me that we could add to this or create a new statute that directly is on point. And again, just my thoughts on it. I don't think that 65305 is a great avenue for that.
Chairman, Representative Oakley, I think you've hit the nail on the head. This statute is, besides the term officer and the definition of officer, it's also the conduct that brings you within the statute that is somewhat questionable. And so my understanding, and I haven't done a lot of, we don't have a lot of legislative history on it, but this is more of a jury tampering type of statute. And so I do think that part of the reason this statute hasn't been used is the action doesn't really fit with the threat of a judicial officer or a family member at home. And I would endorse your thinking, frankly, on a separate assault statute, more specific to the issues that we're concerned about.
Okay, thank you for your comments this morning. We have a couple other judicial topics to get to, and appreciate the wealth of information, and I'm sure we'll have some action taken by the committee here shortly.
Thank you very much, Chairman.
Welcome back, Ms. Butler. We'll talk about the diversion program.
Thank you, Mr. Chairman. Again, my name is Elisa Butler and I am the State Court Administrator for the Wyoming Judicial Branch. I'm going to share my screen with you here.
Ms. Butler, I'm not sure what it was that you said, but it forced the co-chairman to leave. But I think he's coming back.
Mr. Chairman, I sometimes have that effect on people, unfortunately.
I doubt that. Well, thank you for being back up here. Look forward to your comments.
Okay, so Mr. Chairman, I'm here now to talk to you about the diversion program. And so you have this PowerPoint in your materials, but I thought I'd walk through it with you today as well. So on that first slide, what you'll see is a project arising from the governor's 3-branch initiative. So one of the things that we've looked at over the last probably 6 months to a year is working with both the legislative and the executive branches to determine how we can best serve the citizens of Wyoming who suffer from mental health and substance abuse issues. And so as part of that 3-branch initiative, we went on a trip to Miami, and getting people to go to Miami in March was not incredibly difficult. You will be surprised to know. But what they do in Miami is they have what is considered the gold standard of diversion. It's a project they've been working on for about 20 years. It is very, very robust. You have a very good explanation of the Miami model in your materials from LSO. And I think that gives a very good overview of what they do in Miami. We understand that in Wyoming, it will be a stripped down version of that. And so this really is a first step toward providing diversion for those with serious mental illness and substance abuse issues. So in 2022, the Wyoming State Hospital conducted 467 competency evaluations. So competency evaluations, I think you've heard before, occur when there is a defendant charged with a crime, and for some reason, there is a thought that the person is not competent to stand trial. And so before that trial can proceed, there needs to be a finding made that they are competent to stand trial. And if they are not, then they have to be restored to competency before we can proceed through the criminal system and to trial. So many of those competency evals are done by the state hospital. That includes both at the felony level and at the misdemeanor level. So whether it's a misdemeanor or felony, if it's a crime, you have to be competent to move forward. So one of the problems that I think you all have heard pretty consistently about is the wait time for competency evals. That creates a burden on a lot of different people. It creates a burden on the state hospital itself, right? They only have so many beds and so many people who can do those competency evals. It also creates a burden on the jails. And so we've talked to some sheriffs across the state. What happens often is these people are arrested, taken to jail. There is a determination that they need to go through a competency eval, and then those people are held in the jail until they can be sometimes taken to the state hospital for that comp eval. And a lot of times, I shouldn't say a lot of times, but there are times when these folks are difficult to manage. And so what's happening is the jails are having to treat and hold people who really need treatment from providers. So 105 of those competency evals in 2022 were inpatient. Again, it takes quite a while to get inpatient evals done, and 362 were outpatient, which takes much less time. So that is something that I know the state hospital is working on. And I know that is happening across the state. They're doing outpatient evals. 28% of those were for misdemeanor cases. So misdemeanor cases, you all know, low-level crimes, and generally not much jail time, sometimes a fine involved with that. So 61% of people who go through this process are found competent to stand trial. Most of those misdemeanors, so the crimes that are charged, as misdemeanors, are then released for time served. So what we talked about, what I just talked about, that the jails are actually holding these people until they get their competency evals done. Once their comp eval is done and they're found competent to stand trial, then you move forward with the process. A lot of times by the time that happens, they've already served the maximum sentence for that kind of crime. So really what's happening is these people are coming into the system, they're sitting in jail until they can get comp evals done. And then by the time those misdemeanors have their comp evals done, they've already served a couple of months in jail potentially, and we just release them for time served. We're not helping them. They're not getting any treatment aside from what they need in the jail. And then we're releasing them without services. So many times what happens is these people cycle back through the criminal justice system, usually again on low-level crimes. So, it creates a number of problems. Crowding in jails, creating backlogs at the state hospital, excessive jail time for people who have very low-level crimes. So one of the things that the Miami model did to try to avoid this is to provide diversion services. And so this quote, "The failures in services for people with mental illness and behavioral health disorders associated with substance use have resulted in mass incarceration becoming the country's de facto mental health care system." So that's a quote from Judge Leifman, who is the judge in Miami, who really has pushed this and really is at the forefront of this. I think in your materials, what you'll find with the LSO report is that there's a quote in there that over 10 times as many people with severe mental illness in prisons and jails, there are over 10 times as many people with mental illness in prisons and jails than in all psychiatric hospitals combined in the United States. So these people are in our jails. They're not getting the treatment that they need. That's expensive and it's ineffective. So treatment courts provide some relief to this. Though most of our treatment courts are felony treatment courts, they're not misdemeanor treatment courts, and they're post adjudication. So what happens in treatment courts is the person actually has to be adjudicated. There has to be a finding made, and then they go through the treatment court process, which generally is where they get a lot of support, a lot of treatment. And again, mostly at the felony level. The diversion model is designed to divert them earlier in the process. So for low-level offenders who have mental health and substance abuse issues, the idea is to divert them before they even enter the criminal justice system, ideally. And if not, then to divert them as early as possible to treatment and services. So this is what is called the sequential intercept model. And so what this shows is all of the places along the line in the criminal justice system, or when somebody can encounter the criminal justice system where diversion could happen. The first one is community services. So if we have crisis lines, something like that, you could provide them with services at that point. And then intercept one is law enforcement. So what we learned in Miami is many of their law enforcement officers there were CIT trained, crisis intervention trained. So they received specialized training to deal with people with mental health and substance abuse issues. And so when they encounter those folks on the street who are committing probably a low-level crime, what happens is they have the option of either charging them with a crime or taking them directly to a provider for services. And so that's something that we would like to look at. There are sheriff's offices, police departments across the state who have officers who are currently CIT trained. I don't know what the percentages are, but that's definitely an option before they even get to the criminal justice system. Intercept 2 is really what we're looking at here, and that would be basically when a defendant is charged with a crime, a misdemeanor crime, and they have mental health or substance abuse issues, then they could be diverted before they are convicted. So diverted to services, their case could be held in abeyance until those services are provided and they either graduate or, get better. And then potentially that case could be dismissed. So that's really what we're looking at here, is trying to divert those people early so they don't go through the criminal justice system over and over and over again. Right now, we're looking at a pilot for this diversion process in Gillette. It will require joint efforts by the courts, law enforcement, prosecutors, public defender's office, and behavioral health providers. And that is a very important piece. With the behavioral health redesign that you all have heard about over the last few years, the idea behind that is that there will be more community services available for people with mental health and substance abuse issues. And that is going to be really important for this diversion to ensure that when these people do encounter the courts, when they come into the courts, we have a place to take them in the community where they can get those kinds of treatment services. So again, the goal is to divert low-risk offenders who suffer from mental illness and substance abuse and move them away from the criminal justice system to a more effective way to assist them in getting better and becoming contributing members of society rather than cycling through the criminal justice system. I think the last slide on here is just some information about how this has benefited Miami-Dade County. They're very robust diversion system there. So they've decreased crime. They actually were able to close the jail there in Miami-Dade County, which is kind of surprising. They've decreased their homeless population pretty substantially, improved public health, improved safety to officers. So all of those benefits they've seen over the last 20 years with their diversion process. So, Mr. Chairman, that is just an overview, and I would be happy to answer any questions.
Committee, any questions? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Butler, in regards to the pilot program that you're hoping to launch in Gillette, just curious if there's any plans for short-term and long-term evaluation as that progresses.
Ms. Butler.
Mr. Chairman, Representative Rodriguez-Williams, just in terms of the diversion program itself, there would be. So we are actually looking right now at the data that we would like to gather today, before that diversion program is in place, and then the data that we would gather once it's in place to ensure that it's actually effective and meaningful for Gillette, and hopefully, again, the idea is that once we try that pilot program, and if we prove that it is effective, that we can expand that to other locations throughout the state.
Ms. Butler, will there be any statutory changes needed before the pilot can go operational?
Mr. Chairman, I don't know the answer to that off the top of my head. It would not surprise me if there were. I think that's definitely something we're going to need to work through over the next months to determine if there are statutory changes that are needed to implement the program. But I don't know that off the top of my head what they would be.
Representative Oakley.
Thank you, Mr. Chairman. I've got a lot of thoughts and I missed some of your presentation. So if I ask something, I apologize. So is the idea just basically an increased community-based services? Is that really what this is asking for? And I guess the problem is that I'm trying to understand. I love the concept. I think we should work towards going towards this, but I mean, it's people with substance abuse problems and mental illness that don't follow through, right? Mm-hmm. And so, I mean, because I don't think they're around the state, I'm assuming everybody is doing, like, when there's a substance abuse issue, they're getting substance abuse evaluations, they're getting ASIs. I mean, that's certainly being done. So I guess, how does this differ? I'm trying to maybe, grasp and then also talking about the statutory changes, would you be looking at because of course, we have the one time at a 301, or are we looking at doing more diversions statutorily or just dismissals anyway? And like I say, and I apologize if I missed this.
Ms. Butler, there's a few questions in there.
Mr. Chairman, Representative Oakley, yes, to your first question, the idea would be that more robust services would be provided to those people who are diverted, similar to what we do for treatment courts, just pre-adjudication. And so, in Miami, they actually had peer counselors, people who came in and would provide that kind of support who had already been through the system. I don't know exactly what that will look like here, but it would be more services in terms of treatment, and hopefully more services in terms of helping with what we always talk about as the social determinants of health, right? If there are things that program could do to help with, housing or jobs or something along those lines, that is what the Miami model found is the more we help with those social determinants of health, the more successful those people will be in treatment and recovery. To your second question, as far as statutory changes, I think this is big picture and we don't have it all fleshed out yet, but I think the idea would be is for these misdemeanants who go through, obviously there would be a choice. The person would either, make the decision to go to diversion or to go through the criminal justice system. You can't force them to be diverted to treatment. But once that choice is made and they decide to go to diversion, I'm not sure, but I think what would happen is that case, they'd have to waive speedy trial, and that case would just kind of be held until a certain time and then dismissed. Again, that could require a statutory change. I just don't know off the top of my head what that would look like.
Senator Case.
Mr. Chairman, thank you very much. And Ms. Butler, I gotta go over something again on your second slide.
Mhm.
And it was the one about the competency evaluations at the state hospital. And you talked about, you said 467 competency evaluations, 105 were inpatient with an average wait time of 157 days. And then the outpatient, 362, wait time 43.7 days. So that 157 days and the other one, they're incarcerated at that time, right? I mean, or is there a circumstance where they're not during that wait time? This is just astounding to me. I mean, it's like we have people locked up for more than half a year to get them into this slot for a competency evaluation. I mean, so help me. That's what you said, right? That's what this means.
Ms. Butler.
Mr. Chairman, Senator Case, often, yes, they are incarcerated during that time. I don't want to tell you it's universal and happens all of the time, but it often happens. Yes.
My head is.
Follow up.
Yeah, Mr. Chairman, my follow-up is that my head is exploding. And that's just like an astounding waste of all these resources, it seems like to me. And I mean, do these competency evaluations, Mr. Chairman, Ms. Butler, have to be done by the state hospital? Could we have them done somewhere else? And I mean, like in another state, or I mean, we spend a lot of money to lock these people up for all this time to kind of get them through the limited resources of the state hospital. Is what it feels like is happening. And is there a better way? Can we do the more evaluations faster? Locking them up is probably not the best place. I know that's why you're talking to us today, and I'm all on board, but that just seems crazy to me. Help me with that.
Ms. Butler, and online with that, didn't we pass something this last session to deal with at least a misdemeanor evaluations?
Mr. Chairman, Senator Case, there was a statute that was passed, a bill passed this last session that requires, at least initially, that all misdemeanor cases for competency evals be done on an outpatient basis. If they're done through the state hospital, competency evals can be done by other providers aside from the state hospital. That's possible. I think with the behavioral health redesign, I'm hopeful that will help. But I think there have been a few roadblocks here and there with local providers and being able to provide those competency evaluations. So many of them are done through the state hospital. I do know the statute or the bill that was passed this last session, that really was the driver behind it, was to try to cut down on the amount of time that people are spending waiting for competency evals at the state hospital. So the statute actually provides that you can get a comp eval done either inpatient or outpatient for misdemeanors if you do it through a local provider, a private provider or community health provider. For misdemeanors, comp evals with the state hospital, those can only be done on an outpatient basis unless there's a compelling reason to do it through an inpatient comp eval.
Senator Case.
Mr. Chairman, I don't even know what a comp eval entails. I don't know if that's a weeks at the state hospital, so I don't know what I'm asking, but could we do those in another state? Could we hire, if the problem is in Wyoming, could we get it done somewhere else? Could we take them to Colorado, get the comp eval done, bring them back?
Ms. Butler.
Mr. Chairman, Senator Case, I honestly, I have no idea. I think that would be a question better suited for the Department of Health. I don't know if there's any prohibition on doing that. I just don't know, Mr. Chair.
That's always a fair answer. Senator Schuler.
Thank you, Mr. Chairman. I'm excited about this. I hope the pilot program works. I'm just jealous that it's not happening in my community because, again, we have many issues in Evanston because we are the state hospital, many of the folks that get, finally get out, many of them stay in our community and maybe do all right for a while. And then we have issues and they end up in our jails. And again, I think it's a lack of psychiatrists throughout our state and even psychologists, but I do think the legislation that we passed will help to let our community health providers to do some of these evaluations. And I served on that behavioral design committee. So I think we're headed in the right direction, but I guess there is a question here. How long are we just going to wait and get the data from this pilot program before we might determine whether or not it'll work in other areas such as Evanston? Or what are you thinking in that area?
Ms. Butler.
Mr. Chairman, Senator Schuler, I don't know that we have a time frame on when we would expect to ramp this up. I think, again, one of the things that we really need to be mindful of is ensuring that there are treatment providers in communities that when we divert them from the criminal justice system, there's a place for them to get that treatment in their community. And I do think with the behavioral health redesign, that's the goal. But again, that behavioral health redesign is not going to be implemented until July 1st of 24. We are working with the Department of Health. We have regular conversations. Director Johansson actually came to Miami with us. So he saw the diversion project there as well. So, I think everybody's moving in the same direction. I just don't know how long it will take to ramp up.
Ms. Butler, one concern I have is bed availability for treatment providers has been a statewide issue for a long time. And as we prioritize placement of people being diverted out of the justice system, does that further shrink the availability of bed space for other families maybe that are seeking help for a family member, and then they find out there's no place at the end because it's full of people who've been diverted out of our justice system? And the second aspect of that concern is when we start diverting people out of jails that are costing us $60 to $100 a night into a medical facility of some type, is the cost per day higher or lower than the cost of keeping them in a jail where they're supervised by a deputy sheriff as opposed to into a medical facility where they're supervised by medical professionals? I see you brought back up.
Mr. Chairman, I couldn't help myself, but I guess I'll take that one first. Again, this feels like a question for the Department of Health. Provider capacity is kind of the weak link in the whole structure here, and the behavioral health redesign plan should help that. But you need to ask Director Johansson about the details. I do know that part of the behavioral health redesign is to identify priority populations, which include people who are criminally involved. So that, and I think the way it works is that the providers are provided incentives to treat those sort of higher risk populations. How that would impact regular citizens, I can't say. I wanted to address Senator Case's question about the competency evaluations. It is kind of mind-blowing. One of the reasons that we're very interested in this diversion program is that we would not do competency evaluations. First of all, a competency to stand trial is not returning the person to any kind of mental health, right? It's a very limited kind of competency we're talking about. It's not really solving any problems for that person. It's just making them capable of assisting their counsel and knowing what's going on at their trial. So in the long run, it's not helpful to the person. It is a huge burden on the state hospital. There may be other possibilities in the future for ways of getting them evaluations, but right now it's the state hospital, whether inpatient or outpatient. If we do the diversion program, the idea is that there would be a fairly rudimentary jail mental health screening that would be done right off the bat. That's not anything like a competency evaluations, but that identifies mental health issues. And then if the person suffers from 4 major mental health categories, and I think it's schizophrenia, bipolar, PTSD, major depression, if they appear to have that, we're not getting a big deep eval, but if it appears that's the case with possibly co-occurring substance abuse, then and it's a low level, we're talking misdemeanors only, not felonies, nonviolent crime. If they meet these eligibility criteria, then they would be diverted and there would never be a competency eval.
Representative Jennings had his hand up in the co-chairman.
Thank you, Mr. Chairman. So I'd like to go back to, I think what the elephant in the room is behavioral health providers and the evaluation that the senator was talking about. I was currently or not very long ago in a forum that VOA and VA were both there. And in this town. And between the two of them, one of them was more than 300 positions down and the other, I think, was 400. So roughly 700 positions down for those two entities. And yet we're building onto our hospital for mental health. If we do the evaluation, but you have no staff, you have nobody. I mean, I understand that the health department thinks that they're going to have this problem solved or they hope they're going to, but doesn't it seem like this might be the cart before the horse that what do you do with them if you start this program and there's no place to go with them? I mean, Wyoming and Miami are 2 different places. I mean, I was thinking about our homeless. If I were homeless, I'm thinking I'd head for Miami. And so, and they also have a lot more resource than Wyoming, maybe other than the money. I mean, Wyoming has some resource there, but if you can't get the behavioral health people, I mean, you can want to divert, but diverting, it seems like it could create some other problems that we would divert people sometimes who maybe really should be going through the justice system. And I realize it's just on the misdemeanor level. And I realize there's a lot of repeat people that we'd want to deal with if we could divert. And I like the concept, I think was what was said earlier, but if we don't have the people, we don't have the people. And no matter how much money we throw at it, 700 positions down is a long ways down just for two groups, just for the VA and the VOA. And there's other groups that are doing that too, that are down.
Madam Chief.
Chairman Washit, Representative Jennings, you're absolutely right. You've identified exactly, as I said, kind of the weakest link in this program is a shortage of providers. We think, and we've been working very closely with the Department of Health on this. I believe when Director Johansson says, for example, as we discuss this pilot in Gillette, that he can provide the providers. But I agree completely that if that pilot is successful, as we go forward and try to expand into other communities, the hardest thing is always going to be the behavioral health providers. And there are some creative solutions as well that are being discussed, like remote counseling, video counseling, that kind of thing, using out-of-state providers. So I think I agree with you. I recognize that it will be the biggest challenge, but we're working on it, and that's not a reason not to do it.
Representative Oakley.
Thank you, Mr. Chairman and Chief Justice Fox. So, through taking notes, at the end of the day, what we're going to need is funding. I mean, would you agree with that? What I'm hearing, we need to hire more evaluators. We need beds. When we say that that's the missing component, the reality is there are these professionals available, right? But Wyoming is going to have to step up and fund some of this. Do you think that would be a big step towards making this a reality?
Madam Chief, can we do it for free?
No. Mr. Chairman, Representative Oakley. So this is why this is part of the 3-branch initiative. So the piece that you're talking about and Representative Jennings is talking about really is the Department of Health's piece. And they are working on a fairly comprehensive program to have much more robust community mental health services. And so probably, yes, there's an ask for money, but it's not my ask, it's Johansson's ask.
All right. One more. We do have more topics to cover this morning, and I do want to schedule a break. So Representative Oakley.
Thank you, Mr. Chairman. I guess just with all this, I would say, you know, I see that it said it saved the jail or, you know, closing a jail saved 12 million. And of course, as you said, that's it's certainly a higher population. But I would say that I think is important here is the criminal justice system, in my estimation, is used too often when there's somebody who's a danger to themselves or danger to the community. Something has to be done. And I think the criminal justice system is used too often. So maybe a transfer of, you know, resources, but I certainly support the idea and to Senator Case's point of people sitting 160 days in jail waiting for a competency eval. And a lot of times that's used for their you know, health and safety, but it's not I don't think it's the appropriate place. So I think we've got to figure out this piece and I'm obviously giving a bit of a plug or figuring that we're going to have to look at it, and that might attach with some funds. So thank you, guys.
Thank you.
Madam Chief, anything further?
Not for me. Thank you, Mr. Chair.
Thank you both. Let's take about a real 10-minute break, nothing longer than 10 minutes, and we'll come back to the rural attorneys program. 10 minutes. The Wyoming Law School, I believe, is also involved in this initiative. And who's going to go first? Introduce yourself and tell us what we need to know.
Thank you, Mr. Chairman, co-chair, members of the committee. My name is Kelly Neville, and I am an attorney in Laramie in private practice. I'm also past president and treasurer of the state bar and the head of the bar's small, solo, and rural practice working group. I have with me today Pierce Peasley. Pierce is an attorney in Douglas, native of Wheatland, and went to University of Wyoming Law School. Mark Gifford, who is our bar counsel, practiced privately in Wyoming for 30 years before coming to bar counsel office about 10 years ago. And then Professor Alan Romero from the UW Law School. Professor Romero is a grad of Harvard Law, spent some years teaching, clerking, practicing, and about 20 years ago made his way to Wyoming and now has been a professor in mostly property law matters in our state with law students, and he's the head of the Rural Law Center. He's been a great partner with the bar in our initiatives regarding rural law and support of small and solos, which make up the vast majority of the membership of the Wyoming Bar. So we appreciate the opportunity to be with you here today and to start a dialogue about a big issue that's facing many Wyoming citizens, and especially in our rural communities. It's very acute in these areas. In 2020, the American Bar Association did a profile of the legal profession, which highlighted the decrease of the number of attorneys that are practicing in rural communities nationwide. And Wyoming is no exception to this trend. As our baby boomer generations of attorneys are winding down their practices and starting to go into retirement, we are seeing Wyoming communities increasingly underserved by the number of attorneys that are there and available to serve the citizens. And there's growing legal needs as well. So Wyoming has about 1,600 attorneys that practice in state. So these are the ones with an address here in Wyoming who are serving our attorneys, or our citizens with their day-to-day matters and in a variety of other ways. You will see through these numbers, we have 32% of those in Cheyenne, about 12% in Casper, 11% in Jackson, 8% in Laramie, and 6% in Sheridan. So of those 5 communities, that's 70% of the Wyoming attorneys that are practicing in our state. The other 30% are spread across the remaining 18 counties. But all citizens, regardless of where you're located, have serious legal needs, and these needs really vary and cover a large set of areas. Here's some of the areas that are affected, business formation and development. If we want to grow business and have economic development, attorneys are an important part of that process and support that process. Other topics not on here include landlord tenant matters, social security, workers' comp, and this category of estate and inheritance considerations. People need wills, they need medical powers of attorney, financial powers of attorney, they need help dealing with their parents' estates when a parent passes away. We've got adoptions, divorce, custody, and those type of matters. So these legal issues cover all ages of citizens, and they cover all, income classes, education levels. It doesn't matter. A legal need touches every person multiple times in their life generally. So we need an effective system of justice. It's critical for Wyoming's future, and lawyers are a big part of that and this third branch of government. And when an attorney is located in, Cheyenne or Casper, they may be able to help an individual in a more rural community, but it's going to be at an increased cost because they then have to travel at times to that community. And we do have technology solutions that are helpful for some of these things, but they aren't able to address everything, and the problem is still very acute. So we do have this number of communities that you see here that meet this ABA definition of a legal desert. And they define that as 1 attorney per 1,000 population. And when you look at this list of counties, Niobrara doesn't show up on this list, but there are 4 attorneys who show their addresses being in Niobrara County. And of some of these counties here, we have 6 attorneys in Hot Springs County, Crook County has 8, and Weston County has dropped 50% in the last 2 years and is down to 4 attorneys that are practicing there. And it's important to remember when you look at these, while there's that number that report that they're in that community, they're not all serving the public in private practice. They're not all somebody that a citizen could walk up to and say, I need some assistance with a juvenile justice matter for my child, or help, with a landlord. In every county, you have to have at least one person in the county attorney's office, and most of these offices are more than one individual. You also have public defenders, retired attorneys, those that work for a corporation or a nonprofit, and some of them are just not practicing. Maybe they're in another profession, or they're a stay-at-home parent or something like that. So not all of these numbers that I've read to you are available to serve the community. And our 5 most populated counties are just below that ABA or the national average, which is about 4 attorneys per 1,000 people. And if you look at these 8 counties, those are our largest concentrations. But again, even in these communities, there are trouble finding legal services. Cheyenne, of course, Laramie County is going to have a large percentage of the attorneys in that county that are working for state government, whether it be the AG's office or some other capacity. And in Teton County, there are a large number of attorneys either not practicing or doing very high-end estate and business planning, and are not really available to the public for kind of those day-to-day matters that our citizens need. And then there's big limits by topic as well. You may have a number of attorneys, for example, in Natrona County, but there is one attorney in that county who does domestic relations work as their practice. And so, people are having to find attorneys in other communities. So that also limits not only Casper's citizens' access to a domestic relations attorney, but all of the surrounding counties that might otherwise turn to Natrona County for some legal service. And Justice Fox referred to the aging of our bar. It's happening, of course, in many professions, but we are seeing more and more of our attorneys that are in these communities are older attorneys who are starting to retire, and they don't have a successor lined up that's ready to take over their practice and serve their clients. And so the Wyoming State Bar has looked extensively at this issue. We have a strategic planning process, much like the court does. We do that every 2 years. And for the last 4 years, our strategic plan has included a prong focused on support of rural attorneys and small and solo practitioners to better serve the citizens of this state. And we started a working group which includes a variety of practitioners and has had great support from the law school with Professor Romero and the career side and the Rural Law Center. And we're doing a number of initiatives on our own to try to address these issues. They're geared toward really 2 areas. And one is law students. A lot of them go to law school and think they're going to go work for a large firm in Denver and make a great salary. But as people in this trend of moving to more from urban to rural communities that we've seen since COVID and other factors that affect their generation, they're more focused on quality of life. And so this is an opportunity for us to talk to them to consider this career path. What does it look like to be a rural practitioner, and what are the benefits? Think of these communities are wonderful places to live. There's great need. So there's some security for a career, and just educate them on that career path and give them opportunities to prepare for that. We also have some initiatives for existing attorneys, practice support and things to ease them, or, better support them if they're in those areas or they want to make a transition to a rural area. But one missing piece is this jump in between. If you have interested law students, how do we get them into these rural communities? There's barriers, how they're worried about going there. How am I going to find office space? How am I going to cover my costs? How am I going to build a client base so that I can support myself and my family? And spent some time really looking at this issue and how we could create a bridge between the two. And so at this point, I will turn it over to Pierce.
Thank you, Mr. Chair. My name is Pierce Peasley. I live in Douglas, Wyoming, but I'm from Wheatland, Wyoming. I graduated last year from University of Wyoming College of Law, and I'm one of these. I now live in one of these counties that is underserved, and I'm one of the few young attorneys in the state moving to a rural community. And in my time in law school, with the assistance of the bar and Professor Romero, I spent some time and published a piece about the need for rural attorneys in these communities. And We've given today an example. Programs exist in other states to attract and incentivize lawyers in small towns. And some of them have seen good success with those programs. And today we'll talk about the South Dakota Rural Attorney Program. And it's one that is still in place today and has seen good success. So about 10 years ago, the South Dakota legislature initiated this program, and it was designed to get attorneys into communities of 3,500 people or fewer at its development. And in 2019, because of the success of the program, they made that program permanent. And so it currently exists today and is still ongoing. What it looks like there is a program in exchange for 5 years of service in one of these communities, you receive a stipend from the state in exchange for your service in those areas. And the way that they calculate that is they take the in-state tuition at the law school and about 90% of that for fees and tuition, and give that to the participant in a cash payment per year. And so as you can see, about $12,000 a year for 5 years, just as a way to incentivize individuals to move and stay in these small towns. There have been 31 current and past participants out of that program, though. There are currently 11 who are participating, so meaning that they're under contract right now for that 5-year service period. 15 of them have graduated out, and 12 of them have stayed in that community. And I think that's really the important number there to look at, is that 12 out of the 15 who have completed the program have stayed there. And 5 years in one of these communities is a long time, and it allows those individuals to build a practice and to ingratiate themselves in that community and learn to appreciate those communities that they may not have at that time, and then have since stayed there. 5 of them have terminated their contracts, and I think one thing that is of potential interest is that if you do break that contract, you're required to pay back any of the amount of money that you've received, or you can face disciplinary related matters from the state bar in South Dakota. And so there's a bit of a financial incentive for them to stay, but also there's a financial incentive for the state and the entities involved that they'll recoup some of that cost if the individual decides not to stay. They've also, in South Dakota, taken a creative approach to the funding, and they meld the funding with a combination of the of the South Dakota legislature, the South Dakota Bar Fund, and the local counties and municipalities there, in breaking down that cost so that the cost is not all carried by one entity, making it a little bit more financially feasible to get more individuals involved. As you can see here, that they've increased the funding to increase the number of attorneys in South Dakota. When it began, I don't know the exact number, what it began with, but since then, because of the success of the program, they increased the funding to get more attorneys into these communities. Some of the important things is that all of the funds that are taken from this program go right to the participant themselves. There's no costs for, setting up the program. There's no administrator overseeing the program. It's all added to individuals. Any sort of oversight, anything like that is already taken care of by existing entities that exist in South Dakota as it stands now. So there's no position or anything like that needs to be hired to oversee this program ongoing. And this right here is kind of the breakdown of that. So 50% of the money in South Dakota comes from the legislature, 35% from the local county or municipality, and they're able to kind of work that out among themselves. In a lot of counties in Wyoming, as you all know, there may not be too many municipalities in that county, for Niobrara County, for instance, but they can kind of work together to get to that number at 35%, and then 15% is from the South Dakota State Bar Foundation. And I'm going to turn it back over to Kelly now. Thank you.
We just wanted to highlight that the Wyoming State Bar is already putting some significant financial resources to this issue. And one example, I mentioned earlier that we were working to incentivize law students to consider this as a career path and as a future. And one way we've done that is we have donated $50,000 to create an endowment with the law school, and that was matched by some state monies available. And when that money, has sat in the endowment for over a year and we have some earnings off of it, it will be used to send law students over spring break and summer to rural communities so that they have an opportunity to intern with a local attorney and experience it. So maybe they create a connection with somebody who might be retiring and create that contact. And the two of them can then work forward for that attorney to move to that community when they graduate. Or maybe they learn that they're not going to be a good fit for that. And so that helps so that they don't go and have that failure of a practice in a rural community. Because sometimes that does happen too, where they realize it's not a good fit. And let's find that stuff out in a practice environment rather than after they've set up and have multiple clients that depend on them. So we have this endowment that is available, and we expect to be using the earnings and making awards for summer of 2024 and forward. And that just talks about some of the items that could be supported with the endowment earnings. So just, I think this is not a problem unique to Wyoming or unique to the legal profession, and it needs a variety of solutions, but it is very significant for the citizens of the state. And we have the benefit of looking over the last decade at efforts of other states that have done programs like this, and we can kind of pick what has worked best. We need to include things like mentorship. So you put the attorney in this community, and different aspects of the programs that have been very effective has helped them to find a good stable client, like maybe the school district or the hospital, that gives them an ongoing source of revenue for their practice and helps them get their feet on the ground. And mentoring as far as practice, as far as how you set up your practice, and some other practice management pieces that are all parts of these programs. So we can look at the success of these other entities. And just like doctors are so important to our rural communities. And as a state, we have put money into the WWAMI program to make sure that we incentivize medical professionals to get into these communities. This would be a little bit different, but a similar concept of how can this is a critical service that is needed in every community, and what can we do to help bridge that gap from education to career path to get attorneys there. So I would give Professor Romero a moment to speak any thoughts on behalf of the law school.
Thank you, Mr. Chairman. I am keenly interested in the subject and have been ever since 2009, when I successfully proposed the establishment of the Rural Law Center at the College of Law. The law school, under a South Dakota model, would not be involved in administering or funding. But certainly would be an important part of the success of the program, because like in South Dakota, surely the vast majority in South Dakota, all but 2 of the applicants come from the state law school, immediately from law school or after 1 year of an intervening judicial clerkship. So certainly we'd have an important role to play in identifying students. And that's one of the missions of the Rural Law Center, is trying to encourage and support law students to serve rural communities, as well as to provide service directly to rural communities through the activities of the center. I'll just emphasize a couple of things that I think are especially important to conceiving a program like this. One is with regard to the need. The others have spoken about the problem nationwide as well as within our state, and it has been long and well recognized, so I won't elaborate on that. But what I will emphasize is that the need is not just to have resident attorneys accessible to represent clients in rural communities. The ABA's resolution passed in 2012 emphasizes the civic and economic role that lawyers play as well. In the South Dakota, 10 years of South Dakota experience, for example, Hannah Hexgard, she's a professor at the University of South Dakota School of Law, and she's in the process of writing a book about that program and has interviewed all the participants. And she emphasizes that every one of those participants is publicly serving in at least one way, and most of them in more than one way. Whether it's as a prosecutor, a city attorney, a court appointment in defense, commitment hearings. But also they're all extensively involved in their communities in other kinds of civic ways. And that's certainly a traditional important role that the legal profession has played and that the ABA's resolution emphasizes as well. And the other thing that I think is important about resident attorneys as opposed to providing services remotely, which is certainly an important part of improving access to justice in rural communities too, is the economic benefits that come from resident attorneys. One study 10 years ago from South Carolina, but presumably relevant anywhere in the country, found that a resident attorney has a 1.6 economic multiplier. So for every $1,000 that's spent on an attorney, they generate $1,600 of economic activity in the community. So I think there are broader benefits from resident attorneys beyond the most important one, which is access to justice and availability of representation. The other comment I was going to make was just about the benefits of this particular approach, because there are many. And Kelly talked about other aspects of the effort to better attract and retain rural attorneys and to provide legal services to rural communities. And all of those things are important. But this particular model of direct payments supporting prospective rural practitioners, I think, is an essential component of a strategy. From my student perspective, I've seen this in a couple of ways. First of all, of course, a payment like that can be a way to get people's attention, to interest them in the opportunity, an incentive, a bonus, right? And I have surveyed the first year class. You can't escape the University of Wyoming College of Law without taking my class, because we have a small class, and so my property courses are required courses, and I surveyed all of them, and 50% more of the students said that they would be likely to consider practice in a rural Wyoming community if there were such financial support. So it makes a significant difference just in their openness to the possibility. When presented with that possibility, a majority of them, in fact, expressed that they would be likely to consider it. They would be interested in it. Now, that, of course, doesn't mean they're going to do it and succeed at it. And that's the second part I think is important about it, structuring a program and having such a program, is actually helping them succeed. Hannah Haxgard's study that I referred to of the South Dakota program includes interviews of all of the participants over the years in South Dakota, and all of them, well, almost all of them, she says. I think there was one exception, but almost all of them said that the financial support they received was essential to their financial survival. And so the structure and amount of a payment, I think, serves both of those important functions. There are some programs like the Illinois program that the LSO's summary mentions that has an inducement. Right? It's a $5,000 at the beginning and $5,000 after the first year. And that's certainly a bonus and attraction, maybe to draw attention to it, but it's not going to help somebody really survive the early years of establishing a practice. In Hannah's interviews, she concluded that 5 years was really the ideal amount of time for those people who had experienced it to establish a practice. And the amount, of course, it may depend upon budgetary considerations, but having an amount and a duration that is sufficient to both attract but also to support during that difficult transition period. Now, you might wonder, well, why do rural lawyers need that more than any other lawyer? Well, part of that is because they're much more likely to be solo or small practitioners. They don't have a structure that they can just go to begin a practice. And that's certainly much more common in Wyoming rural communities than in the less rural communities. The last comment I'll make is just about considerations prospectively and maybe unnecessarily, but I'll just acknowledge that there are a lot of approaches. You've seen some of them in the LSO's report. Personally, I think the direct payment model, rather than a loan repayment assistance, for example, is a better model. For what it's worth, the New York State Bar had a task force that studied the variety of approaches, and they concluded that the best approach was the direct payment model of South Dakota. And part of that, of course, is that loan repayment is variable. And so it may not be equitable as a way to support, but also because the money isn't just to offset the cost of legal education, but it's to help somebody establish a practice. But the other kind of programmatic considerations, of which there are more than I should or will mention, but just I guess acknowledging and maybe encouraging your collective reflection about is just how to structure the program. There is a kind of tension between the flexibility that makes those programs workable and the desire to ensure that it has the features that you want that will produce the desired results. And there's been some variety among the state approaches in that respect too. The South Dakota bill is very flexible and just basically authorizes the judicial branch to establish a program, and the courts have worked out all the details, and they weren't legislated. But there's lots of features of a program that could be built into legislation, such as integrating mentorship, which is certainly an important part of the success of these programs. It's mode of administration, the structure of oversight and performance. But I think the success of the South Dakota model suggests, and Hannah's study, by the way, also emphasizes the importance of flexibility in order to really succeed, because individual circumstances for applicants will certainly vary. And so the more flexibility that's consistent with the public objectives, the more likely it is to be able to adapt as needed.
I've just got a few words to share with you. Again, my name is Mark Gifford. I work for the Wyoming State Bar as bar counsel, and I wear a lot of hats in that role. One is attorney discipline. The Wyoming State Bar is charged by statute with administering the legal profession, the regulation of the legal profession in the state of Wyoming. And we serve as an administrative arm of the Wyoming Supreme Court in that role. We're a small staff. There are 8 of us. I'm one of 2 lawyers employed by the bar. I practiced for 30 years in Casper and took the position with the Wyoming State Bar in 2011. So I've been at the bar now for 12 years. I will offer that in the bar office, we have a pretty good finger on the pulse of what's going on with the demand for legal services in the state. And we can kind of monitor that 2 ways. We offer a lawyer referral service that people can either call us or get online on our website and try to get matched with an attorney in a particular area of the law. What we find is that we're just not getting attorneys in rural areas to sign up with the lawyer referral service. And I think there's a couple of reasons for that. A, there's not many of them. B, the ones that are there are really busy. And so they're not looking for referrals of clients. The other way that I kind of have a good feel for what's going on out there is we have an ethics hotline. And I take calls and emails, dozens every week from lawyers. We're trying to assure that they're practicing ethically,
But a lot of those turn into a conversation about what are you doing? And a lot of those calls come from attorneys that are really stressed in areas of laws where there are not enough attorneys to go around. Family law, guardians ad litem in cases involving kids. Those are hard jobs. They don't pay very well. The people that do them hold a special place in all our hearts. But there is a dearth of lawyers, and especially in the rural areas in those practice areas. Another point that I'd like to share with you is that last June, several of us, Kelly Neville and I, and a couple of others from the bar, attended a conference in Deadwood, South Dakota. One of the programs was put on by graduates of South Dakota Law School that have gone into this rural practice program. And these are, I'll call them kids because I can afford to at this point in my career, but these are young lawyers who are working in rural communities. And I wish you could hear them, and maybe we can bring them before the legislature at its session if we have that opportunity. They have a story to tell. They graduated from law school. They signed on with this program. They are working in small communities and they're sinking roots there. And they're being invited to serve on boards, nonprofits and otherwise. They're enthusiastic about building their practices in these small towns, and they are really feeling a niche, and it's rewarding for them. And that's why you saw the numbers. That's why these attorneys are sticking around after they finish their 5 years where they're subsidized with an annual payment. So we're excited about this. We're a little bit behind. South Dakota got a 10-year head start on us, but we can catch up. And we've got a blueprint for success with the South Dakota model. There are other states that have similar programs, and they've approached it differently in terms of funding and administration. And the last thing I'll say is we have brought, thanks to Professor Romero's help, we've brought a template of what an enabling statute might look like. And we've based that on what South Dakota passed in 2013. I've also got the South Dakota statute for comparison, and I've got a red line copy, but with the chair's permission, I will provide those to LSO staff, and I've brought sufficient copies for everybody. So.
Thank you very much. It's been very informative. I want the committee to ask some questions, but I just want to remind everyone, we do have a hard break. We have a lunch appointment for the committee. So please keep your questions pointed and brief. It would also be good if all of our committee members would make sure you turn in your travel forms to me before you go to lunch. And I think we'll put off committee actions in terms of bill draft requests and those sorts of things until after lunch. So Representative or Senator Cooper.
Thank you, Mr. Chairman. Could one of you kind of address to me what the starting wage for a freshly graduated attorney might be in the state of Wyoming right now, as a general guess, so we know kind of what we're trying to subsidize here?
Ms. Nabel, whoever at the table.
Thank you, Mr. Chairman. And Senator Cooper, I can tell you what I make in Douglas. Certainly not shy about that. I make just short of $50,000 a year moving to Douglas. So not significantly much for somebody when you are getting incentives and job offers from bigger communities and bigger firms that are also wanting attorneys. So.
Follow up.
Thank you, Mr. Chair. Sir, would you say that at $50,000 a year, you have the ability to repay your student loans as necessary?
Mr. Beardsley.
Thank you, Mr. Chair. I went to the University of Wyoming College of Law for a reason, and that was the affordability. And I worked hard to get scholarships for everything like that. So I'm very fortunate that I don't have the student loan debt that some of my fellow graduates have. As it stands now, it still is tight, and my wife has gone back to work for that reason. But, you know, rural communities are more affordable to live in, certainly, than some of the other communities. But the housing market in Wyoming is also not the most affordable as well compared to the state. So there are certain things to consider, but it is enough, but just barely.
Senator Furphy.
Thank you, Mr. Chairman. One of the points I wanted to make, as I was recruiting executives for the banking industry, one of the things you got to remember is the spouse. So if you're going into these smaller communities, I would approach the leadership in those communities, make sure the spouse can have some work too. Otherwise, the couple isn't going to stay there for very long. So just point that out. Thank you.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. So one of the issues in our community is conflicting out. And I'm just curious if there's any studies either by the bar or by the university that speaks to that issue specifically in Wyoming and access to representation in regards to that.
Mr. Romero.
I wish I had this open. My computer's not cooperate. Mr. Chairman, Representative Rodriguez Williams, it most certainly is a problem. And maybe Kelly would do a better job of characterizing it. But when you ask the question, I realized that we actually have some data on that subject because we asked we surveyed the state bar, this working group that as you referred to in late 2020. And it was striking that among the smallest, the 8 counties with the lowest attorney to population ratio, 70% reported having problems with representation conflicts compared to 33% in the largest 8 counties. So the difference is dramatic. And we've now had 3 conferences talking about this issue with members of the bar from across the state. And it is a recurring theme that it's one of the most difficult problems for rural practitioners, and a reason why, having even 3 isn't enough. Right? Yeah.
Representative Shostak. Representative Rodriguez Williams.
Thank you, Mr. Speaker. And then just in regards to your endowment program, has that committee or board of that for your law school looked at other approaches internally other than funding attorneys to serve during the summer? And the reason I ask is because personally, I don't think Laramie accurately shows the beauty that really exists throughout the state of Wyoming. And so I'm just curious if your students do get the opportunity to come up to Park County and see how wonderful other areas of the state are, and just looking at other approaches to use that funding.
Please send your letters to Representative Rodriguez Williams. Ms. Neville.
Yes, Mr. Chairman and Representative Rodriguez Williams, we have had conversations. So Legal Liftoff is a spring break program where a student is only committing to 5 days in a community, and it is supposed to be outside of Laramie. You don't do legal liftoff in Laramie ever, and the summer ones also would not be in Laramie. And it also is easier for some of the practitioners who maybe don't have the time and ability to mentor a student for 6 to 8 weeks in the summer. They can commit to 1 week, or we've even seen like in Douglas and Saratoga, some practitioners got together as a group and hosted a student for the week and kind of gave them each, a couple of days experience. And those were very rewarding experiences. We've talked about kind of a roadshow approach, maybe taking some students over a short break to tour a few communities and meet some of the courts and practitioners and some different things, yes, to expose them to this places in the state they might not have been and types of practice and benefits that they might not have thought of.
Representative Shostak.
Thank you, Mr. Chairman. And I thank you for the presentation. Very, very informative. I'm a huge supporter of what you're trying to accomplish. I take your point about the direct payment method. The subsidy method is probably better than debt relief, although we can talk about that and if this proceeds further. My question, though, is I think we have what I like about the program is it helps people as they're launching their careers. But I'd like to hear a little bit more about what we're doing to try and recruit students into the program while they're still students. One of the things I love about teaching at the University of Wyoming Law School is we have students in my class who are from all over Wyoming. That's sort of the niche of the school is if you want to practice law in Wyoming, go to the Wyoming Law School. And we have students from all over the state, including a lot of rural students already in our classes. But they tend to get pulled into the bigger cities when they have debt to pay off and they need a higher salary. So what can we do while they're still in school to recruit them into the program and get them signed up so they're ready to launch when they graduate?
Mr. Romero.
Mr. Chairman, Representative Chestek, I think that the existence of a program would go a long way to accomplishing that, right? Just whatever version it is would create a path that students would be aware of and that we could help prepare them for and facilitate them traveling. Ever since the Rural Law Center was established in 2009, I have informally advised and supported and encouraged students, and they self-identify with me that they're interested in that kind of work. And of course, also with our career services director. But I do think the more that we have these kinds of targeted programs like the legal liftoff program, the summer internships that the State Bar has funded. And if we had a program like this as well, I think there would be a well-recognized track that students could be pursuing from the beginning of their law school career.
One last question, Representative Jennings.
Thank you, Mr. Chairman. I'll try and be brief. So it's good, wonderful presentation and I think it's great, well thought through, and probably this question won't go anywhere. But as legislators, not lawyers, well, I think there is a lawyer or two here. But we like to hear both sides of an issue and that there might be some negatives. Have you guys, I don't know, do you have any reservations about programs with bringing the government in? I mean, do you want to, your profession, do you really want to pull government into your profession more? I mean, just, are there any negatives that y'all can think of?
Anyone?
Oh, yeah, Mr. Chairman, Representative Jennings, I'll make one comment, which is not really a negative. As I've looked at discussions of efforts throughout the country, I haven't really, it's surprisingly, actually, little dissent, right? It seems like unanimity about the importance of the issue and they need to do something about it. So negative comments or critical comments are usually about choices of approach. And Wisconsin is the most skeptical of the jurisdictions I'm aware of. Their state bar studied the project, the issue, and concluded that rural lawyers didn't really need financial support. What they needed was simply to promote and encourage and prepare students for that kind of work. And so that's the focus of their rural initiative there. And we certainly need to do more of that too, and would be responsive to Representative Chestek's question too, that, you know, we need to and intend to improve our training at the law school to help students be prepared to practice even solo upon graduation. But I think that I suppose, you know, you commented about government involvement. You know, I think these objectives could be accomplished using funds from any source. And there are some efforts that have drawn from non-governmental sources and have also borne fruit. On this scale, I think public support is really necessary to have this kind of a South Dakota direct payment model. None of the programs that haven't had governmental funding are nearly so extensive. And I think it also, an important part of this model is the participation and contribution of the local government, which I think has contributed to the success of the South Dakota program.
Well, I thank everyone this morning. Unfortunately, the clock is working against us at this point. We will hold public comment on judicial topics after we return from lunch, before we get into the corrections topics. And we will do the committee work in terms of bill draft requests and other things after we return for lunch. But thank you, everyone. I'm sorry if there's anyone in the group that has to hold over from lunch, but that's what the clock tells us to do. So thank you very much. Great to see you all.